So what am I here to talk about today? As an attorney, as a licensed, trained attorney specializing as a copyright attorney, um, I noticed that there's some inconsistencies with what's being reported as far as the legal liability for this thing. Not the least of which is this article. CrowdStrike's terms and conditions say most customers would just get a refund. I disagree with this article. I think CrowdStrike actually owes a lot of people a lot of money to the point that CrowdStrike might need to do bankruptcy to reorganize or liquidate. But this lawyer says they don't know anything beyond refunds unless you're a big company and you didn't have these terms of service somehow didn't apply to you. And I don't think that's true. So I wanted to go over some things today. So I took a whole bunch of notes here. Of course, companies have terms of service. And we're going to look at CrowdStrike's terms of service here. This is the software terms of use. We're not going to read all these words, but it says, please read carefully, you and any company or entity you're acting for accepts these CrowdStrike terms of use by installing or using the software. Great. CrowdStrike may update these terms. There's a section of definitions. There's a license to use the software. You have a license. Of course you have a license. The software user has obligations. You are responsible for your third-party provider. CrowdStrike can use some data. Here, there is no warranty. No software ever has a warranty. They're always disclaiming the warranty. This software and all other CrowdStrike offerings are provided as is without warranty of any kind. CrowdStrike and its affiliates disclaim all other warranties, express, implied, statutory, or otherwise. Full stop. Done, right? That's the end of this video. There is no recourse for anybody, especially CrowdStrike customers who have signed this terms of service or agreed to this terms of service by using the software, right? Not quite. First, there's a few things already in here that indicate that's not entirely true. To the maximum extent permitted under applicable law. So there's already a limit. They agree that there is an applicable law and a limit on that. CrowdStrike and its affiliates and suppliers specifically disclaim all implied warranties of merchantability. We're going to talk about that. Fitness for a particular purpose. Title, warranties of title, non-infringement with respect to the use of software and all other CrowdStrike offerings. There is no warranty that the software or any other CrowdStrike offerings will be error-free or that they will operate without interruption or will fulfill any of the software user's particular purposes or needs. Don't you love how you have to buy something? You're going out to buy a wrench that fits a very particular size of hexagonal nut. But before you can have your wrench, the store hands you a piece of paper and says, this wrench does not work for that nut. We do not guarantee that this wrench works for that nut. And if it doesn't work for that nut, you have no recourse against us. Even though we're selling you a 5/16 wrench for a 5/16 nut, we will not warranty it for use on a 5/16 nut. Does this sound ridiculous? This is where we are today. This is where we've been for decades. Software is made for a particular purpose or made to work, but you are buying it and it's not guaranteed to work in any way, not even a little bit. It maybe does work or people wouldn't buy it, but if it doesn't work for you, your problem. There's no guarantee. Software user acknowledges that CrowdStrike does not guarantee or warrant that it will find, locate, discover, prevent all software users or affiliate systems threats. Okay, so it might not catch your threat. So you're buying it to catch threats, and it does not have to catch the threats. Just so you know. To the maximum extent permitted by applicable law, CrowdStrike shall not be liable to the software user under any theory of liability, whether in contract, statute, tort, or otherwise, for lost profits, revenues, savings, lost business opportunities, lost data, special incidental consequences, punitive damages, etc. This sounds really scary, and this, frankly, I think is unethical. It's definitely immoral. I think it's also unethical because by putting things in your terms of service that sound like users don't have any rights. The only limitation is here to the maximum extent permitted by applicable law. So you, the user, then have to know your applicable law and what the maximum extent it permits is. This is ridiculous. This is a ridiculous state of affairs. It is redonkulous. It is so ridiculous. It's as ridiculous as a donkey. Any donkey. But these sorts of agreements do not automatically provide unlimited limitation of liability. So the complete limitation, the full limitation of liability is actually limited by applicable law, which I will talk about after I look at my notes. The question then is, in the case of CrowdStrike, when you push a corrupt file that causes widespread system failures, could that potentially overcome this disclaimer of liability? Well, we have a few things here. First, not everybody has signed this. This might be applicable to the vast majority of cases. Maybe 90% of cases are CrowdStrike customers who have been directly affected and would now want to make a claim and would be limited, in theory, by this, if it limits them. But there are also some customers, or should I say not customers, there are also some people who have come in contact with CrowdStrike software or been affected by CrowdStrike software who did not sign it. So they have a different evaluation of their claims because they don't have to go through the terms of service and overcome this limitation of liability. But the big one that I want to talk about today is gross negligence. So gross negligence is a tort claim. Negligence is a tort claim. Negligence is the theory that someone might owe you a duty of care, some basic duty of care, like your doctor might owe a duty not to harm you in the process of doing surgery, not to harm you outside of the norm for the surgery. Okay, let's a clean hypothetical. If your doctor messes up, your doctor slips, then your doctor did not deliver that duty of care. If that slip up causes damage to you, then you would have a claim. So duty, injury, breach, and cause. Did the doctor have a duty of care? Yes. Did they injure you in the hypothetical? Yes. Did they cause the injury? Have you been damaged? Yes. So in the CrowdStrike scenario, the question for basic negligence is whether CrowdStrike owed their customers a duty of care. They did. They definitely owed some kind of a reasonable person's duty of care. They're holding themselves out as a highly trained expert software company at catching these malicious software programs, viruses, malware, etc. And they didn't maintain that duty of care. They breached that duty of care by pushing this software update that caused all this stuff. Obviously, lots of people were injured, and obviously they caused it. So far, we're not really having a hard time with negligence. So if there wasn't a contract, if there wasn't a terms of service disclaiming liability, then you can, yes, affirmatively contract around liability for your negligent acts. You can sign a waiver, and when you get hit by a paintball at the paintball gun festival, you can't sue the festival because everybody expected you to get hit by paintballs. That's what you agreed to. However, if the paintball festival in my hypothetical forgot to put the cover over the punji stick pit, and somebody fell in and died in the punji stick pit because somebody forgot to put the steel plate cover over the punji stick pit, that's not basic negligence anymore. That's gross negligence. Something way out of the norm, something not within the normal scope of negligence, the normal, reasonable, understood risks that are being taken. In the punji stick case, of course, having such a dangerous thing at a paintball range where you're supposed to be able to safely shoot paintballs at each other without falling into punji stick traps. Yeah, you shouldn't have that at a paintball festival. That's an instrument of war. Like, you don't need to have that as at a paintball festival. So you get it. If CrowdStrike is liable for gross negligence, none of this matters. It will be overcome by gross negligence. Let's give you a couple examples. There was the Heartbleed bug. Remember OpenSSH back in 2014? I thought it was earlier. So Heartbleed was introduced in March of 2012. It was a buffer overread bug in OpenSSL. It would allow attackers to read up to 64 kilobytes of memory from a server running the vulnerable version. It affected a major portion of the internet, websites, and services, and caused widespread concern about data security. Various companies using the OpenSSL library faced litigation. Plaintiffs argued that these companies were negligent in their cybersecurity practices and failed to patch the vulnerability in a timely manner, leading to data breaches and potential exposure of sensitive information. The primary legal issues were negligence, breach of implied warranties, and failure to implement reasonable security measures. Many of the lawsuits were settled. Companies agreed to improve their security practices and compensate affected users. Specific settlement terms included monetary compensation, credit monitoring, and commitments to enhance cybersecurity measures. That's a little bit different than what happened here. That was a open source library that was being used by many companies, and many companies were liable to many people. Here you have one company, CrowdStrike, using a closed source library, as far as I know, and this one company liable to many, many, many people. There was also the Target data breach. Target had a data breach that affected 40 million credit and debit card accounts. Why do we care about this? This isn't gross negligence. Well, not everybody has a agreement with Target to limit their liability, so Target was liable for all of the ancillary services. The investigation had to be paid for by Target. The reissuing of debit and credit cards was paid for by Target. Various state attorney generals sued Target for the costs of the data breach that individuals aren't going to sue for the cost of the Equifax breach or the Target data breach. So Target might not have a limit, a liability limit with everyone, so those plaintiffs will still have claims outside of any limitation of liability. But you can also overcome the limitation of liability in court by showing some things. This is California, so I looked up California cases. There's a 2007 case, City of Santa Barbara versus Superior Court. The California Supreme Court held that a liability waiver cannot exculpate a party from gross negligence. The court defined gross negligence as the want of even scant care or an extreme departure from the ordinary standard of conduct. This case is frequently cited. Then I have three more that are against fitness centers: Chavez versus 24-Hour Fitness, Jimenez versus 24-Hour Fitness, and Anderson versus Fitness International. These are various cases that say that when gym equipment falls on you because it wasn't maintained properly, that's gross negligence, and you can't contract around that with the standard gym liability waiver. So that's not going to work. So what about CrowdStrike? Did CrowdStrike push an update that departed from ordinary standard of conduct, and that departure was extreme? Well, let me go to their own website, because they released a statement about the whole thing. They apologized. They're going to work with everybody. We've mobilized our team, etc. Here are the technical details. CrowdStrike released a sensor configuration update. I'm assuming sensors doesn't mean like temperature sensors, but rather like sensors for incoming malicious software. Sensor configuration updates are an ongoing part of the protection mechanisms of the Falcon platform. This configuration update triggered a logical error. This configuration update triggered a logic error, resulting in a system crash and blue screens on impacted systems. Now, doesn't that sound benign? A logic error. There was a logic error. No. A logic error is a simple brain fart. That's a logic error. That's a simple brain fart should not be able to get pushed out to millions of people's servers. A logic error is, oh, I forgot to put on my socks before my shoes. A logic error is simply forgetting to do things in the correct order or apply the correct true, false, or conditional logic. This is not an act of God. This is not a tsunami. This is not a cosmic ray striking a single bit and flipping the bit and causing a system to crash in the middle of an update. Maybe it is. I will defer. I do not know. I will defer to the people who know. But this does not reassure me that it was an act of God or catastrophe or racing incident, F1 fans. This is not a racing incident, in my opinion. This is potentially gross negligence. The sensor configuration update that caused the crash was at 5:27 UTC on Friday, July 19th. Not a cyber attack. The configuration files are referred to as channel files. Updates to channel files are a normal part of the operation. This is not a new process. The architecture has been in place since Falcon's inception. So then why, if I understand this correctly, the contents of these of the corrupt files is simply zeros. They simply wrote zeros to a file and pushed that out as an update. I don't know the rest of the details. So yeah, it's a user, or rather a developer error. It was channeled file 291. There's a support portal that's set up. We understand how this issue occurred, and we are doing a thorough root cause analysis to determine how this logic flaw occurred. Hang on, help me with this English. We understand how this issue occurred. We are doing a thorough root cause analysis to determine how this logic flaw occurred. What? We understand how this issue occurred. We are doing a thorough root cause analysis. That is not good English. Those are two contradictory parts of the same sentence. Efforts ongoing. We are committed to identifying any foundational or workflow improvements we can make. Yeah. They're in, I mean, this is as panic mode. The ship is sinking as you could possibly be right now. Maybe they're better now than they were yesterday, but still, the ship is on its way down, and they need to stop it sinking. Because I truly believe, from a legal perspective, that everybody who has been directly affected, everybody who has a proximate cause legal claim, which I'm going to talk about in a second, might actually have a claim, because this might be gross negligence. And if this is gross negligence, it's not gross negligence to some people. It's gross negligence to all of them. So they're going to have a real fight trying to prove that this is not gross negligence, and plaintiffs are going to have a real fight proving that it is, although I think plaintiffs have the easier fight. So you've heard me use the highway analogy before when we talk about proximate cause, and I think you've heard me talk about Ms. Paul's graph as well. Whether or not a particular plaintiff has a successful claim for gross negligence against CrowdStrike is going to vary. It's going to vary based on proximate cause. It's going to vary based on legal cause. In tort law, you need two types of causes. So duty, breach, injury, and cause, you need two types of cause. You need but-for, or factual cause, and you need proximate, or legal cause. So you need factual cause and legal cause. I've used the highway analogy before. You're driving down the highway and you come to a stop in traffic. The traffic is caused by a drunk driver who had a major accident a mile up the road. It's halted traffic. There's no way to exit. You're not even in a place where you could park your car and go walk where you need to go. And where you need to go is a very important business meeting. You're about to be hired and you're already completed all your interviews. They've guaranteed your position so long as you show up. You just have to show up on time to your new job and you've got the job, but you're late. that you can call. Maybe you can't even call, but no matter what happens, the calling's not going to stop it. You need to be there on time, or you don't get the job. The drunk driver had an accident. Now you're not going to make your job, and you've lost your dream job. You've lost many, many, many dollars, millions of dollars a year from your dream job. You're never going to get it back. This has tainted your reputation, and you can never get it back. You don't have a claim. At least in the US, we generally don't recognize long legal causal chains unless there is a foreseeability, reasonable foreseeability on the part of the defendant. So the drunk driver could definitely be held liable for driving drunk and causing an accident with the people that they hit, the people who were immediately directly affected by it. But the drunk driver probably can't be held liable for all of the hundreds or maybe even thousands of legal claims for all the traffic that got backed up on the highway. And the reason is we don't expect anybody, drunk drivers, to reasonably foresee that when they drive drunk, they're going to cause some guy a mile back to be late for his dream job and lose his job. That's not something that you are really expected to think about when you're drinking at the bar and about to get in your car illegally. So yes, the drunk driver is liable, but not liable to you after a number of remote occurrences. A similar case is the oft-cited case of Long Island Railroad versus Ms. Palsgraf, or rather Palsgraf versus Long Island Railroad. I forget. I think the order got changed around in appeals court or something. Ms. Palsgraf was a innocent victim of the railroad. She went to the platform to board her train, and there was a commotion. A conductor who is not supposed to be helping load cargo was helping a man load a box of cargo. The box of cargo fell over, and its cargo spilled out onto the platform. Its cargo was fireworks. The fireworks were unstable and began to explode. The explosion caused commotion on the platform. There were oxen that were getting ready to load the cargo cars of the train. They bolted and tipped over some cargo scales that are used to calculate shipping costs. These are massive metal scales that weigh hundreds of pounds. They fell over and they injured Mrs. Palsgraf. No legal liability between the railroad and Ms. Palsgraf. Remember, the conductor didn't injure Ms. Palsgraf. The conductor didn't have anything to do with the fireworks except they helped load them and contributed to the fireworks tipping over. A conductor loading fireworks, back up. A conductor loading cargo, unknown to them, should they reasonably foresee, if I load this cargo, there's a good chance that it'll tip over and explode, and oxen will cause a commotion, and that will injure someone after scales get tipped over. No, the conductor is not expected to foresee all of those consequences. Therefore, the conductor and the railroad are not liable to Ms. Palsgraf. Sure, the guy who brought the fireworks illegally onto the train might be liable to Ms. Palsgraf, but that wasn't the question in that case. So the question here is what happened to any one plaintiff in the CrowdStrike incident reasonably foreseeable by CrowdStrike? Yes. Yes, CrowdStrike software is used on PCs, Windows PCs around the world. It's used by businesses. It is sold to businesses specifically to keep their businesses running. So you can't say that they can't foresee that their software that keeps the businesses running would affect the businesses running. So then the question is whether this was gross negligence or whether it is just basic negligence. Sure, they owed you a duty. Sure, they breached it. You waived that duty. You waived that remedy. You waived your remedy in negligence. So your only remaining remedy is either that you didn't sign this contract, or that this contract is unconscionable, or maybe that the company represented some sort of warranty to you. Those are all great arguments. But the big one is whether this rose to the level of gross negligence. And I think everybody's got at least a claim course, this is not individual legal advice. Go talk to your own attorney before you just go make claims. But if you've been directly affected, your company has been affected, maybe even the airline passengers, although again, you're starting to get more remote. Maybe the airline passenger is too remote. Maybe the airline passenger only has recourse through their airline. And it's the airline that has a claim against CrowdStrike. Maybe both have a claim against CrowdStrike. But if it's gross negligence, or in order for it to be gross negligence, as we saw, it needs to be outside extreme carelessness or reckless disregard for the consequences. So reckless disregard is known, should have known, or willful blindness. So should they have known about their vulnerability, about this logic error? Should it have been caught? Would it have been reasonable for it to have been caught? Or was this an extreme departure? Did they not implement a certain test or testing procedure, unit tests, hash tests, that sort of thing? What didn't they do is going to be a big deal. If they did the things and it still happened, then maybe it's not gross negligence. But if they didn't do the thing and they were supposed to, if they knew, should have known, or were willfully blind, then it is very likely that they will be held liable for gross negligence. I understand why development companies want to be liable for absolutely nothing. They just want to make software and then fix problems and not have their company be under this kind of scrutiny. But they're also offering software that provides security. It's kind of like providing a police officer or a bouncer and then saying like, oh, by the way, we don't have to provide any security services even though you've hired us and paid us, which is actually a true thing for police officers. If you're not aware, police officers do not have any duty to any one individual. They may create one. If a police officer caused an incident, then they have a duty. But without causing an incident, if you just call the police and say, someone else is attacking me, please come save me, they have no duty whatsoever to attempt to save you. Whatsoever. But that's in the U.S. and is something most citizens don't know. So yeah, that's my take on the CrowdStrike thing. See if I have any more notes on my 34 copies of notes. Class action lawsuit. So there does need to be commonality among class action participants, class action members. And they do. They all have commonality of cause. They'll all have different damages measures, though. So it might be an interesting class action lawsuit where the judge first determines liability, yes or no, for the class members against CrowdStrike, and then has to do separate little hearings on damages for each category of class member: airline passengers, hospital patients, the hospitals, the airlines, etc., the businesses. So while CrowdStrike's EULA, end user license agreement, may help them with some users who might be deterred not knowing what their rights are or not wanting to go through the fight, or maybe they weren't affected that greatly, I don't think that their EULA does much to protect them from motivated actors. Motivated plaintiffs should be able to make claims against CrowdStrike. Whether you win or not, I'll leave that up to you and the courts and between you and your attorney. I'm not your attorney. I'm just reporting. I'm Leonard French, your favorite copyright attorney. And let me know what you think in the comments below.